If you have questions about what we're talking about today, estate planning questions, probate questions, questions in general, or just want to talk, go to planwithgary.com. You can set up a time to talk in person or on the phone. planwithgary.com. Later in this video, we will go over a more detailed definition of a trust. For now, just remember, it is a way to protect assets and pass assets to others without the need for judges and courts. That is, no probate. A revocable living trust is just one part of your complete estate plan. Revocable means you can change or revoke the trust. Living means you establish the trust during your lifetime. If you understand the advantages of a revocable living trust first, then you don't need to understand the inner workings. It's like a clock. You can either understand how to tell time or understand how the clock works. Only a watchmaker needs to know both. Like the watchmaker, attorneys need to know how trusts work and what the result is. You should understand what a trust can do for you more than you should know all the inner workings inside and out. The advantages of having a trust are many and are presented here in no particular order. All the assets in a trust are not subject to probate. Probate is the process of admitting the will to court and following the instructions in the will to move your property to other people. Probate is public. Your private life will be included in the court record, including an inventory and accounting. This means that everybody can find out how much you are worth. A trust makes assets available to other people, your loved ones, quickly and easily without the need to go to court and see a judge. Probate can take years and tie up the money and other property until complete. Probate can be a very expensive and emotionally draining process. If you look at the table, you will notice that probate runs 6% or more of the value of the estate. With a trust, you completely avoid probate and save that 6% for your loved ones. Not to mention, they get access to the money and other assets quickly without court intervention. Trust can protect children with special needs or people receiving government benefits. A trust can be set up to supplement public benefits while not destroying their eligibility for those benefits. Trusts protect children with substance abuse problems. You can set up a revocable living trust to pay for their living expenses directly, making sure they have a safe place to live, but not give them enough money to make their habit worse. The same goes for children with chronic debt problems or chronic gambling problems. Trusts protect your assets and property now and later. The trust protects your goods now by providing for a second or third trustee to manage the trust property if you can't for any reason. Later, a new trustee takes over and follows the instructions in the trust, typically distributing the property in the trust to other people. Trusts make sure that your children don't squander the money. Trusts can provide for higher education among other things while preserving assets. You can set up a trust to pay landlords, schools, and bills directly while providing an entertainment and food allowance to your children. Trusts leave you in control now and later. You can continue to manage your money and other assets long after you're gone. You can attach strings and conditions to spending the money. Trusts protect your assets in case of incapacity. A revocable living trust is a very efficient way to protect your assets. If you become incapacitated, then your successor trustee, whom you have already chosen, steps in and takes over management of the property in the trust. You have handpicked the person you trust to take over management of your property and can rest easy. Trusts protect your financial rights. Trusts leave instructions on how to manage and distribute your assets. That is, how to invest and spend your hard-earned money now and later. For example, you can request the money in a trust be invested with a certain advisor in the way you want it invested, conservative or aggressive. You can delay the passing out of assets until people are at a certain age or other conditions are met. You might say you keep strings on the money. Trusts protect jointly owned assets. If something were to happen to you and your spouse at the same time, a revocable living trust will work to protect the assets and provide for your needs during your period of incapacity. Trusts can avoid two probates. If you and your spouse pass together or closely together, then even jointly owned assets would be subject to probate without a trust in place. You should go ahead and establish your trust now, rather than after the passing of the first spouse. If the second spouse no longer has the mental capacity to sign a contract, then they can't create a trust. It protects out-of-state real estate from probate. If you own property in more than one state, then you should really consider a trust. If not, probate must be done in more than one state, adding to the cost and time. You can create a trust in your home state, then have the out-of-state property deeded to your home state trust. Once you do this, the trust rules take over. What is common to all trusts is that they require an agreement and something to hold in trust for a third person. In a trust, one person gives property to another person, the trustee. The other person then is trusted to manage that property for the benefit of the third person or people, the beneficiary. A trust terminates under certain conditions. A trust is a contract between two people for the benefit of a third person. The two people are called the grantor, or trustor or settlor, and the trustee. The third person is usually called the beneficiary. A grantor is the person creating the trust. They are one party that must sign the contract. A grantor is a required person for creating a trust. The trustee is the person that the grantor gives the grantor's property to. The trustee is trusted to manage the property for the benefit of the beneficiary. The beneficiary is the person who benefits from the property in the trust. A trust is a bucket you put assets into. Somebody gets to hold the handle and control the bucket. That person is the trustee. The person who puts stuff into the bucket is the grantor, the trust maker, or the trustor. The person who gets to play with and eventually own the stuff in the bucket is the beneficiary. The beneficiary is the person that will benefit from the stuff in the trust. Along with the stuff, you put a set of instructions that anybody else who holds the handle must follow. The word revocable means in law that you can revoke something. In the case of a trust, it means you can turn off the trust if you have the legal capacity to sign a contract. Furthermore, you will probably reserve the right to change the trust or make amendments. A living trust is a trust you create during your lifetime. So a revocable living trust is a trust created during your lifetime and is revocable during your lifetime. And typically, during your life, you play all three roles of trustee, grantor, and beneficiary. It is only after you and your spouse's passing that a new trustee comes in and the final beneficiaries become active. While a trust is a powerful tool, there are some things that a trust just cannot do for you. You can't shield assets from Medicaid. A revocable living trust is considered an asset for purposes of Medicaid. However, you can revoke the trust and deal with the money in other ways. You can't protect assets from creditors. Since the assets in your trust are considered yours, creditors can still reach your assets, at least while living. You have reserved the power to transfer the assets back to yourself, so the assets are available to you to pay the creditors. A trust can't preserve your medical decisions. You need other documents to protect and preserve your medical decisions. A trust has nothing to do with telling doctors and loved ones your wishes for ventilation, hydration, and any other medical decisions. You need to create a medical power of attorney, a HIPAA waiver, and a living will. Each of these plays a role in your medical decisions and form a cohesive whole. Preserve all your financial and legal decisions. You have some decisions that fall outside a trust. Durable powers of attorney are what you need to have somebody you trust make legal and financial decisions for assets and things outside the trust. For example, if you're in a car accident and are sued, your trustee cannot answer the lawsuit. Finally, a trust cannot take away everything from your spouse. Your spouse may still be able to claim their elective share. In Re. Estate of Thompson, 2014 Arkansas, an elective share is the minimum under law you can leave your spouse. In Arkansas, this is typically 1/3 of all non-real estate outright and a 1/3 life estate and real estate. A life estate means that your spouse has control of the property during their lifetime, then at their passing, ownership automatically passes on to the next person in line. Setting up a revocable living trust is not difficult with the proper guidance. However, you should keep in mind that a trust is a complex legal document full of little things that can come back to haunt you. With that said, the first step is to decide you want a trust. Once that decision is made, most people opt for the revocable living variety. Before visiting your estate planning attorney, you need to decide who the successor trustees will be. Successor trustees are the people that will take over during your periods of incapacity and after you are gone. You can pick different people for different situations. For example, you may pick your spouse and your son that is a financial advisor, then finally your oldest daughter. You also need to think about what property you want to put into the trust. You need to weigh the pros and cons about each item of property before putting it into the trust. You may opt to keep your cars out because they are typically short-term items. but you may decide to put your collectible car in because you will keep it a long time. Your attorney can help you with these decisions. Once you decide the successor trustees and what property you want in the trust, it is time to visit with an attorney that practices almost, if not completely, in the area of estate planning. The attorney will draw up the trust to match your desires, then help you put all your property into it. You need to revisit your trust anytime you have a major family change or event, or every 5 years, whichever is sooner. Events after which you should revisit your trust include marriage, divorce, adoption, birth of a child, graduation of a child, your graduation, or a spouse's passing. A revocable living trust is classified by the IRS as a grantor trust. This means that as long as the original grantor is alive, income tax is paid by the grantor and not the trust as a separate entity. This is a good thing because the tax rate on trusts are not as favorable as personal tax rates. If you have questions about what we are talking about today, estate planning questions, probate questions, questions in general, or just want to talk, go to planwithgary.com. You can set up a time to talk in person or on the phone. planwithgary.com. You can also call or text 479-717-6300. Thanks for watching today.